And welcome back, everybody. Back here at the live desk tonight. We're at the top of the hour. We broke the news that the federal appeals court has ruled in favor of Michigan's ban on gay marriage. And right now we're taking this story further. We want to bring in Cooley law professor Curt Benson for some analysis on this. Curt, I know that none of us have had an opportunity to page through this 75-page ruling. But your take on it right off the bat, this 2-to-1 ruling in effect is what? They want to put this into the hands of the voters?
Well, yeah, basically what they're saying is, look, it's not the proper role of the federal government to second-guess the wisdom of state legislature. It's a classic federalism decision. I mean, it really is the classic conservative versus liberal. Conservative view saying, look, we have a constitutional structure, federal government, limited powers. This is an area traditionally handled by the states. The federal government has no business telling the states what to do. The dissent says, no, wait a minute, what the states are doing are violating their citizens' equal protection under the laws. Therefore, it's the federal court's role to step in and prevent the constitutional violations.
Michigan's Attorney General coming out saying this is putting it to the Supreme Court. Obviously, this is an issue that is on a collision course with the High Court.
It really is. As a practical matter now, the Supreme Court's going to have to hear this. See, the reason the Supreme Court said we're not going to hear the cases is because there was no disagreement among the trial courts and the courts of appeals below. Uniformly, the federal courts were saying bans against same-sex marriage is unconstitutional. Well, lo and behold, Sixth Circuit comes along and said, no, it's not unconstitutional. Therefore, Michigan banned, Ohio, Tennessee, Kentucky, all of their bans are now the law of this circuit. Now it's in direct conflict with California, New York, Utah, the other states where federal courts have said it's unconstitutional. So as a practical matter, unless the Sixth Circuit reverses itself, which is possible under something called an en banc decision, not likely, but possible, the Supreme Court as a practical matter is now going to have to hear the case because there's a conflict that must be resolved.
But as you were saying, it doesn't necessarily put this issue on the fast track for the High Court.
Not a fast track, but they'll probably have to pick it up next time it comes down the road, if that makes sense. It's not like they're going to order immediate briefing emergency, but the next time it comes up, they'll probably pick it up.
All right. Curt Benson with Cooley, we appreciate it tonight. Thank you for the analysis. Sue, we'll send it back up to you. A huge decision today.